Can you sue an influencer for shilling a coin? That is a question I've been getting a lot over the past few months, and I purposely have not answered it because I've been doing a ton of research into the matter. And in today's video, I'm going to be laying out what I think is probably the strongest cause of action against influencers who shill coins. So here we are in 2021 with the fraudulent business cycle of scam coins. Create a scam coin, pay an influencer to promote the scam coin, gather hype for the scam coin and get initial investment, then pull the rug on the scam coin. It is just a vicious circle that keeps on repeating. And perhaps the biggest problem with this entire thing is that the individuals who create these scam coins are often anonymous. They use aliases and act exclusively through the internet, so they are almost impossible to track down. So this begs the question, do the influencers who they pay to promote their scam product have any sort of legal liability? And I would argue yes. And it's not just a little sliver of liability for the entire crypto scam. There are laws which you could argue the influencer could be held responsible for the entirety of the damage that is caused from the crypto scam. Let's look into it. Now, everybody bear with me a little bit. I'm going to move over to this little sliver of the screen, and we're going to go over the Securities Act of 1933. Now, the first thing we're going to need to establish for the Securities Act of 1933 is a cryptocurrency a security? And here is the definition of security, and I'm going to pause the video so you can read it if you want. Now, whether you read that long, boring definition of a security or not, the most relevant piece of information you need to know is that courts have routinely found that cryptocurrencies are securities. So if a cryptocurrency is deemed to be a security, the Securities Act of 1933 would apply. Now, if the Securities Act of 1933 applies, there's one section of this act that I want to talk about as it pertains to influencers, and that is Section 12A2. Now, as you can see here, it says Section 12A2 creates liability for any person who offers or sells a security through a prospectus or an oral communication containing a material misstatement or omission is liable to the purchaser for rescission of the purchase or damage, provided that the purchaser did not know about the misstatement or omission at the time of the purchase. Court holdings imply that the cause of action only applies to purchasers at an initial offering, not secondary purchases, but this is not settled law yet. Investors suing under 12A2 can only recover from the sellers. Now let's click on Section 12A2 to learn a little bit more about it. So as you can see here, this is 15 USC Code 771, civil liabilities arising in connection with a prospectus and communications. In general, any person who offers or sells a security in violation of Section 77E of this title or offers or sells a security, whether or not exempted by provisions Section 77C of this title, other paragraphs 2 and 14 of subsection A and said section, by use of any means or instruments of transportation or communication in interstate commerce, or by the mails, by means of a prospectus or oral communication which includes an untrue statement of material fact or omits state of material fact necessary in order to make the statements in light of the circumstances under which they were made, not misleading the purchaser, not knowing of such untruth or omission, who shall not sustain the burden of proof that he did not know, and in exercise reasonable care could not have known of such an untruth or admission, shall be liable to subsection B to the person purchasing the security from him, who may sue either in law or in equity in any court of competent jurisdiction to recover the consideration paid for the security with interest therein, less the amount of income received therein upon tender such a security, or for damages if he no longer owns the security. Now that might have sounded like a bunch of legal mumbo jumbo, but let me tell you why that's important. Under that statute, you can sue anyone who is considered essentially a statutory seller of the securities. They don't need to be the owner of the securities. They don't need to be the creator of the securities. They don't need to be on the executive team of the securities. they are just somebody who sold or shilled the security, and they knew that there was a material misstatement or a material omission that they should have disclosed. So essentially, only statutory sellers are liable under Section 12A2. And here's an article written by a law firm who often defends securities litigation. So Section 12A2 only imposes liability on ones who offer or sell a security. It requires that the defendant be more than a mere participant in securities transaction. A defendant must be a statutory seller, one who either actually passes title to the purchaser for value or who successfully solicits the purchase of securities motivated and leased by a party to desire to serve his own financial interest or to those of the securities owner. And I would argue that an influencer becomes a statutory seller the second they are given any amount of the cryptocurrency they are shilling, because they literally have a financial interest in the coin going up. And if they dump said cryptocurrency at the launch, that's a statutory seller to me. An example of this would be an influencer knowing that a cryptocurrency is a scam and deciding to promote it anyway. Now, as you saw earlier, while it is unsettled, case law points to really only being able to do this cause of action during an initial offering. So with that said, the criteria in which I think an influencer could be held responsible, potentially for the entirety of the scam, is 1, cryptocurrency is deemed a security. 2, the influencer slung or shilled the cryptocurrency at the initial coin offering or very close to it. 3, the influencer knew the cryptocurrency was a scam and they materially misrepresented the cryptocurrency while they shilled it. And if the influencer knew the cryptocurrency was a scam, a material omission would be, hey y'all, this thing is a scam. Now, if you don't believe me, just ask The Game. The rapper was hit with a $12 million judgment for promoting a fraudulent ICO in 2017. The coin was called Paragon Coin, and the founders of Paragon Coin have allegedly declared bankruptcy and fled the United States. Now, I did look at the lawsuit, and in the lawsuit, everybody was sued. So Paragon Coin, the entity, was sued, the creators were sued, and all the influencers were sued with it. And in this particular lawsuit, all the parties are jointly and severally liable for the judgment. Now you might be asking, what does jointly and severally liable mean? Well, let me give you an example. Let's say you sue 10 people. 9 of those people cannot be found. Let's just say they're anonymous internet trolls. Well, the one person who can be found is on the hook for everybody. So in theory, if they can't identify or find the other parties to the lawsuit, The Game could be held responsible for the entirety of the judgment. And as you can see here, the language they are using in the article relates back to Section 12A2 and creating a statutory seller. The Game acted for his own gain or for Paragon's gain in California's court. So once they prove that he's a statutory seller, he is on the hook for securities fraud. So if you know of any influencers admitting that they knew the cryptocurrency was a scam and it fits the other criteria, don't worry about making a coin a security. That's probably the lawyer's job. But the other 2 criteria, initial coin offering and they knew it was a scam, the influencer could potentially be held liable for everything. So they can't hide behind the excuse of, oh, it was the dev team, and I don't know who the dev team are. They're anonymous. Nobody knows who they are. I got scammed as well. That excuse ain't gonna fly, or probably won't fly. Lawyers can't guarantee anything. All right, y'all, that's it for today's video. Thank you so much for watching. Make sure you hit that like button and consider subscribing to this channel. We just passed 370,000 subscribers. We're growing like crazy. And again, if you know of any instances that might fit this particular criteria, send me a message on Instagram. I want to take a look at it. All right, y'all, talk to you later. Bye.